And now we are starting our masterclass with the lecture by Dr. James Lewis. James Lewis is a Senior Vice President at the Center for Strategic and International Studies. Before joining CSIS, he worked at the Department of State and Commerce as a diplomat and as a member of the Senior Executive Service. His experience includes a broad range of diplomatic and political military assignments. Dr. Lewis helped develop policies of encryption and the Internet. He led the US delegation to the Wassenaar Arrangement Experts Group on advanced civil and military technologies and was a rapporteur for the UN Group of Governmental Experts on information security for 2010, 2013, and 2015 sessions. He led a running track of 2.5 discussions on cybersecurity with the Chinese Institute of Contemporary International Relations. Dr. Lewis has authored numerous publications since coming to CSIS on cybersecurity. He is frequently quoted in the media and has testified numerous times before Congress. Lewis's current research examines how the Internet has changed politics and how digital technology will reshape society and international relations. He received his PhD from the University of Chicago. The floor is yours, James.
Thank you, Heli, and good morning to everyone. My appreciation to Estonia for undertaking this very important effort. I'm going to give you some background on the negotiations in the first committee and put that in the context of building a framework for responsible state security. Cyber operations, cyber techniques are another tool for coercion and attack, and the principal source of risk is states. That means building an agreed framework on responsible state behavior is crucial for stability. This began in 1998 when the Russian Federation proposed a treaty. Treaty may not be a bad idea sometime in the future, but at the moment it's premature. A treaty faces serious problems in terms of there's no agreed definition on what is a weapon, what is an attack, how you would verify it. So while the issue of why don't we have a binding agreement continues to come up, it's the difficulties of defining this binding agreement that make it important not to rush into it. The UN First Committee, however, began a series of negotiations. The first of these was, of course, the Group of Government Experts, the GGE, now in its sixth round with 25 experts. In 2019, the First Committee also added the Open-Ended Working Group, in part as a way to address some of the criticisms of the GGE, that it was closed, it was secretive, there wasn't a chance for other countries to participate. And one of the things we've seen in the OEWG sessions is broad global interest. I think at the first session, 140 countries showed up, about 90 of them spoke, deep knowledge and concern in many nations. So the OEWG and the GGE work together to create and reinforce this framework. These negotiations are, as are all UN negotiations, a consensus process. Everyone must agree. And this, of course, puts a ceiling on what can be done. Sometimes you hear complaints that the agreements, the agreed texts aren't ambitious enough. That's because of the need for consensus. There's also, and those of you who have negotiated know this, there's a value to ambiguity. Ambiguity helps in reaching agreement. The agreements that we have, and in particular the 2015 GGE report, whose conclusions were endorsed by the General Assembly, follows a negotiating logic, not the logic of lawyers or academics. And it's worth noting that as you do preparatory work on this, that sometimes media coverage and academic analysis can be confused. In 2017, for example, many people announced that the UN negotiations were over, that they were dead. That turned out to be wrong. Let's quickly walk through the history of the three agreed texts. In 2008, a number of academics, including myself, proposed that we think of an alternative to a binding agreement that would involve norms and confidence building measures as the basis to build trust that could eventually lead to some stronger agreement. And the models we used were the Missile Technology Control Regime, the Treaty on Conventional Forces in Europe, the Helsinki Agreement, very much an arms control approach at the start of this process. In 2010, there was agreement for the first time in the GGE. It's worth noting that this agreement was only 94 words, but it set the agenda that we have followed ever since. Norms, CBMs, and capacity building. On capacity building, it's worth noting that this was not part of the original text, and the South African expert said that speaking as a representative of the developing world, he would block consensus unless we added capacity building. So from those very few words in 2010, we've seen a whole growth of efforts on capacity building, on creating norms, and on developing confidence building measures. Norms, of course, are what states should do, what they should not do, and how they interact with others. Norms are not binding in the context of the GGE reports. That's not necessarily bad, and we can talk about that later. There's some issues that are off the table in the group of government experts, and part of that reflects its first committee mandate. The first committee, as you know, focuses on disarmament and international security. So topics of espionage, crime, internet governance are not part of the discussion in either the GGE or the OEWG. They're recognized, of course, as factors that could diminish stability in cyberspace, factors that could affect international security. But they're largely handled in other groups, the UNODC, the IGF, IGF Plus now. These are the groups under the second committee and other UN bodies that tackle these issues. It's not a dilemma because there's plenty of work when it just comes to international security, right? 2013 and the GGE report of 2013 were in some ways the breakthrough. I should note that one thing that has been consistently true is the GGEs have all had very strong chairs. And the strong chairs are Russian and Australian, a Brazilian, and now another Brazilian, have been instrumental in their success. The chairs are the ones who, at the end of the day, have to pull the agreement together. 2013 put cybersecurity in the existing structure of international relations. This immediately makes it a much easier problem for people to understand, for people to deal with. It emphasized the centrality of the UN Charter, the concepts of state sovereignty, international law, and of course the Universal Declaration of Human Rights. So 2013 saw agreement to embed cybersecurity in the existing structure of international relations. I should note that in these discussions, the required expertise is not technical, right? Sometimes you'll hear a complaint, well, there should be more technical experts in these discussions. At the beginning, when I first participated, we had technical experts in the room, and they were helpless. These are negotiations on international security, and the expertise you need is political, it's in non-proliferation, it's in security in general. And now, of course, we have this new set of expertise in cyber issues. So not technical, definitely not lawyers, but political and security focus. So 2013 in some ways broke the barriers for what we thought we would be able to do. 2015, of course, is the crucial agreement. It built on the agreement of 2013. It's crucial because it was endorsed by all member nations unanimously in the 2015 UN General Assembly. The 2015 agreement, as you heard, laid out 11 agreed norms. It identified a range of confidence building measures. and it again discussed the need for capacity building. This is a package that fits together when we think about the framework for responsible state behavior. Norms tell states how they should act in cyberspace. Confidence building measures build the trust that other states are also following those norms. And capacity building gives states the capability to both observe norms and participate in confidence building exercises. So these three elements fit together into a package that allows states to interact and to build security and stability in cyberspace. The 2015 agreement identified CBMs to expand transparency and to improve cooperation. It defined state responsibilities under existing international practice and commitments. And this is worth noting because sometimes people feel like, how can I understand cybersecurity? How can I participate in these negotiations or discussions? And the answer is it's not technical expertise. Helpful to have, of course, but it's not important. What's necessary is an understanding of your national interests in cyberspace, the existing agreements you already have under international law, under the UN Charter, the Universal Declaration of Human Rights. These are the things that shape our discussion. And so 2015 saw the creation of a framework for responsible state behavior that was agreed to by all UN member states. We now have two sets of processes going on. It's worth noting that there was another GGE in 2017 that did not reach consensus. And the reason it didn't reach consensus is largely because there was an effort to define how international law applied. What we've seen is all nations agree that international law applies, right? But they do not want to become more specific in how that applies in cyberspace. They want to leave that to national discretion. And there's some key issues here. What is the use of force in cyberspace? The use of force is, of course, the term in Article 2.4 of the UN Charter that talks about the limitations on states and their military activities. But there is no agreement on how to define use of force. We've tried in the past, particularly in 2013, to develop a definition of use of force, but those were politically unacceptable. You can have groups of lawyers or you can have groups of academics write definitions that are brilliant. I felt my own definition was brilliant, but it was rejected in about 2 minutes in the negotiation. And afterwards, I asked one of the leading Western negotiators, why did you object to this? And what she said was, it wasn't Helly, it was the British expert. What she said is, my prime minister wants to reserve the right to decide when something is an armed attack or use of force. Armed attack isn't defined. It's worth noting that these things are also not defined in the UN Charter. And going back to the point on ambiguity, it's agreement if you have a concept, use of force, but you leave it to nations to decide how they will apply that. It's easier to decide how you would perceive an armed attack, and this is where national discretion comes in. There's an informal understanding that attacks that cause death, casualties, destruction, probably qualify as an armed attack, right? There's something that needs still to be worked out in international discussion. One of the areas of ambiguity in this is physical destruction. We all understand when you see a building, damaged or destroyed, we all understand that was an attack. What if the target is data? What if the damage is logical? What if it's erasing databases or frying servers? Does that qualify? The answer is probably yes, but there is no agreement on that. So one of the tasks for the next few years is to come to a better understanding internationally on what qualifies as an armed attack. But right now, it's very much left to national discretion. And many states prefer it that way. This is one of the obstacles to a treaty, is that we will need to come up with these better definitions of what qualifies as an armed attack. Of course, there's been discussion in regional groups on these. NATO took many years, beginning in 2007 with the uh, interference with the Estonian government's internet connections. Did that qualify as an attack? Did that trigger Article 5 of the NATO agreement? And it took many years for NATO to work through that. It will take even more years to develop an international consensus, but that's the path we are on. UN member states agreed at the General Assembly to observe the 2015 recommendations, and it's worth looking at those 11 norms. They are exceptionally valuable. They provide us with a good framework to define how states should behave. There's some important parts in there. There's an agreement not to attack critical infrastructure, contrary to your obligations under international law. Now, this was a point of some dissent, and it remains so, because the initial language wanted to say no attack on critical infrastructure in peacetime. Several states objected to that. The second iteration was no attacks on critical infrastructure, contrary to your commitments under the Geneva and Hague treaties. And there was objection to that as well. The formulation that ultimately worked was no attacks on critical infrastructure, contrary to your commitments under international law. And those commitments are described a few paragraphs later. It's the commitments to observe proportionality, distinction, discrimination, the principles of the laws of armed conflict and international humanitarian law. We'll hear more about that later today, but people were unwilling to say the names of the conventions, the actual references to LOAC, still an issue, laws of armed conflict, but they were willing to acknowledge that these principles applied. So there is in the 2015 agreement a single paragraph on how international law applies. It's worth noting that in discussions with experts in the current round of talks, both in the GGE and in the open-ended working group, some major countries have said, while they can live with the language that's in the 2015 agreement that says that international law applies to cyberspace and to state behavior, they cannot go much further than that. In fact, they can't go any further than that, or they will withdraw consent. So we have a ceiling on international law, and in some ways that makes this easier, right? Because we have an ability and a flexibility to come to agreements in this area, right? What's the value of non-binding norms? And you hear this very often. Well, it's not binding, so therefore it doesn't account. First of all, you have the agreement by all member states to observe the 2015 norms, right? And to be guided in their behavior by these norms. That's a crucial fact. We have a global agreement on how states should behave in cyberspace. Norms provide guidelines for state behaviors. They give states an idea of what is expected of them, right? And equally important, they provide a justification for potential responses to a state who fails to observe its obligations under these agreed norms, right? And this has become one of the central issues for our discussion is how do you respond when states do not observe norms? Now, this is not a new problem. You see this in other arms control areas. You see this in human rights and in states' behavior. One of the models for thinking about cybersecurity is responsibility to protect, also not binding. There are many precedents in the UN for thinking about how to take action against a state that fails to observe its international obligations. And this is where the 2015 norms in particular are important. You sometimes hear that we need to work with countries to help them implement the norms. You don't implement norms, it's not like a cookbook. you observe norms, right? And so how do we get countries to observe and conform their behavior to the agreed norms? And this leads us into a difficult issue of countermeasures and retortion, things that are allowed to states to take action in response to someone who violates the 2015 norms. A difficult area, another one where we were unable to get agreement uh, in the context of the UN. But again, if you have an understanding that the UN Charter applies, your behavior is defined by these norms. If you do not observe the norms, it allows other states the potential to find punitive responses. And this has become a crucial element. So where are we now? As I said, we have two negotiating processes. The Group of Government Experts, GGE, and the Open-Ended Working Group, the OEWG. They're different in that the OEWG involves all member states. It allows for participation by non-governmental actors. There's been some dispute over this. A couple countries have said we do not want uh, the private sector, we do not want non-governmental actors participating in the OEWG. That's created some limitations, but there are groups that have been approved by the UN in other contexts that have been allowed to speak. The OEWG is open. You can watch its deliberations online. So it's a great process for developing deeper understanding, a broader participation in the discussion of international cybersecurity. It's worth noting, and sometimes people say, well, if you have two groups that have almost exactly the same mandate, how do you avoid them from coming into conflict? How do you avoid them from, uh, turning into rival camps? And part of the answer is very strong chairs in both groups. I've mentioned earlier the importance of strong chairs. The chairs coordinate closely. And so I'm very optimistic that, in fact, the OEWG and the GGE will come up with complementary actions. In fact, the advantage of the GGE is it turns out it's easier to have deep interactive discussions among a smaller group of experts. When you have 140 countries in the room, if one says something and when you go through the list of speakers, it might be a half hour before anyone can respond, right? In the GGE, it's interactive. People sit across each other from a small table and they can talk. There's broad interest in these discussions. At the request of the Department of State, we prepared a backgrounder on the negotiations. It's a guide to what's going on in these things. I think it's on our website. What are we facing, though? We're facing significant differences in national views over a rules-based approach and over universal values. I sometimes worry that if we were to negotiate the Universal Declaration of Human Rights again, we would not have consensus on it. But we do have it now. There's again dispute over how these values apply. Some people say we need new norms. There are a couple that are out there, one on the core of the internet, one on election interference, that might be useful. But in point of fact, most activities are already covered by the 2015 norms. And the goal, of course, is how do we increase state observation of these norms? How do we ensure that states' behavior is in accordance with this framework for responsible state behavior? The issue on CBMs has changed. There's been remarkably successful work in regional groups on implementing the confidence building measures agreed to in 2015. And in particular, I would point to the Organization for Security Cooperation in Europe, the Organization of American States, the ASEAN Regional Forum, and now the African Union. These regional organizations are the center of activity on confidence building measures. And they've done remarkable work in reaching agreement among their members. But In the future, we may very well have to think about non-cooperative CBMs among states who are essentially hostile to each other. This was not the case in 2015. We assumed that everyone was more or less in agreement politically. Whether that was true or not then, it's certainly much less true now. And over the course of the negotiations I've been involved in four, we've seen this area of agreement shrink. And that, of course, creates a more difficult environment. And so we do need to think, when states are unfriendly, how do we build confidence? What do those measures look like? How do we do that in a way that reinforces the observation of the agreed 2015 norms? Okay. A difficult issue, and we opened by talking about the Russian proposal to have a binding treaty. I actually agree with some of the Russian points. We probably do need to ultimately have a binding treaty. That's years off, right? We probably do need to have better understandings of some of the definitions. The nature of warfare has changed. The 2016 election interference was a new kind of warfare, not necessarily covered, at least in detail, in the UN Charter or in the existing agreements. So we do have a lot of work before us, but the starting point for that must be the framework for responsible state behavior agreed in 2015, states' observation of that framework, and if it's not observed, the potential for response or retaliatory action against those who've transgressed. Cyber is a difficult field because it does not pose an existential threat. When you think of the whole series of arms control and non-proliferation agreements that were developed in the 20th century, their starting point was the Cuban Missile Crisis, where the world came very close to nuclear war that frightened many countries, including the two leading nuclear powers, and they began a process of agreement. We don't have that existential threat yet driving us in cyberspace. This reduces the incentives for agreement. There's still room. I think we will see agreement out of both of the groups now, but the process will be longer, reinforced and accelerated, of course, as we become more dependent on the internet. So whereas cyber was not an existential threat in 1998 or in 2010, it may very well be an existential threat by 2030. And that will help us as negotiators. Cyber will be part of the international agenda moving forward, part of the international security agenda moving forward. It's an area where all nations must develop expertise. And one of the lessons we've learned, I'm sure you'll hear about it later on, is capacity building must include capacity in policymaking for cybersecurity issues. This is a long process. We are in some ways only 5 years into it, but there's been remarkable success that I expect will be duplicated in the current round of negotiations. Delayed, of course, by the COVID virus, but something that in 2021 we can expect to see a new set of agreements among all UN members. And so on that optimistic note, I'll stop and leave the floor open for questions.
Luis, for your thank you for your really good explanation of all these questions. We have received a couple of questions from the audience, and if I may, to read some of them. First question: how the non-binding norms will contribute to cyber stability? What is the role of norms? And how do you see nation states will recognize and respect the norms of responsible state behavior in cyberspace? Because, as we know, there are norms are non-binding in the 2015 GT report. So
that's a great question, and it's central to our discussion. I think what we need to think about, though, is that the application of these norms, the development of these norms, creates guidelines for state behavior. we now can say, what does responsible state behavior in cyberspace look like? So the fact that they're non-binding isn't that important, frankly, for me, because states have agreed, I will follow these. If you think about many agreements, the Missile Technology Control Regime, for example, very important, not binding. Binding, not a crucial point. What's crucial, and this is true for many international security issues, is that there's a common understanding. We have that thanks to 2015. And now some mechanism, some activity to encourage observation of those norms. And I think that's the space we're moving into. It's not so much that we need new norms, it's that we need actions to ensure that states observe them. I think that will define much of the activity for the next few years. So the fact that they're non-binding does not mean they do not have force. The norms do have force, and it's up to states to make sure that they're observed.
So, thank you. Then we have heard from you about the question of international law and how this has been central in the GG discussions so far. As all of us sitting in the UN First Committee debates, we know that there is also some politics involved with international law. And sometimes those discussions have less of the legal nature than political. So how you maybe can comment on this aspect of international law application, and we, of course, are encouraging the fact that the existing international law should be applied because we think that this is key for us and to make sure that there is cyber stability ensured.
Yeah, that one of the worst mistakes I made, I think it was in 2013, was I proposed to the chair that we take all the lawyers in the room, because many countries bring lawyers in their delegations, that we take all the lawyers and send them out of the room and have them have a working group to discuss legal issues. And this was very helpful because it allowed us to make progress on the text that was finally agreed in 2013. The dilemma was that when the lawyers came back, they thought we were actually going to pay attention to what they had said. And that sounds a bit awkward because there are strong political disagreements between major powers on how international law applies. All countries agreed that it applies, but they did not agree how it applies. And that reflects differences in a couple areas. One, and I hope we'll hear from this from some of our other colleagues, is if we endorse international law as applying to cyberspace, if we talk about how it applies, if we define use of force or armed attack, which are the terms used in the UN Charter, this will legitimize warfare in cyberspace. And a few nations say the internet should be a zone of peace. The ones who say that are ones who we know have very strong military capabilities. Well, that's negotiations for you. So many other countries say, oh, let's be serious. Dozens of countries are developing military cyber capabilities. Let's make sure that they're embedded in the existing understandings and commitments on the use of force, on the use of military operations. This is a profound area for dispute. Some countries would prefer to see the rule-based order eroded so that they can change it in ways that re-emphasize the importance of national sovereignty. To give a quick potted history, in 1945, at the end of a fabulously destructive war, all nations agreed we can't have this happen again. And so they developed the UN Charter, they developed the UN Declaration of Human Rights. States essentially gave up an element, a portion of their sovereign control. They said sovereignty is diminished, universal values take precedence. And now there's a number of states that would like to reconsider that bargain. They would like to see sovereignty increase its influence. And you hear this sometimes in the discussion, well, these universal values, when you say I'm not observing them, you're interfering in my internal affairs, right? That's the debate, is that you agreed to give up some of your sovereignty in human rights and in the use of force, and now people want to reconsider that agreement. And some of it just reflects the high level of distrust. The level of distrust, which was high in 2010, has only increased. So one of the tasks for the negotiating groups now is to think about what are the mechanisms we can develop in the UN context. And everyone agrees on the centrality of the UN. The UN is the place where these discussions must happen. That gives states a leading role. But in that UN context, what are the mechanisms we might want to develop to increase trust so that countries are more willing to make progress on some of these difficult issues, like the application of international law. At times it can be humorous from an external point of view. In 2013 and 2015, the last two agreements, a few states objected to references to Article 51, the inherent right of self-defense. Now, the objections are feckless. They do not have effect. Everyone has agreed under the UN Charter that Article 51, the right to use force in response to an armed attack without going to the Security Council, everyone has agreed to that. So why not put it in the cyber agreements? And people were afraid that if we did that, it would justify retaliation. It would justify offensive operations. So you had this unusual situation of people objecting to references to Article 51. By it's implicitly agreed to by the commitment repeated multiple times that the UN Charter applies, that international law applies, but there was no agreement to name that specifically. And I think that's where, between the discomfort, between the lack of familiarity with this new kind of warfare and these new technologies, people will need to think through how international law applies. We don't want to rush to any conclusions if we want to win agreement. But let me pause on one note, if you don't mind. The issue is not whether or not international law applies. Everyone agrees to that. They won't describe how it applies, and that means it's up to states, like-minded states, to develop and implement those understandings. They have to be credible, but that might be the basis for reaching agreement in the UN, is that the task now falls to the states that believe in international law to begin to talk about how it's implemented, to begin to put that forward. We won't get agreement on that this year, but if we start to define it, it will move us in the right direction.
This certainly is true that states have to also show the way and come up with the international law implementation and how they see international law applying. And it follows kind of naturally that we are still battling with the accountability when it comes to the state conduct in cyberspace. And may I also ask you, how do you see attribution and increased accountability could help to implement the cyber stability framework?
It's good that we have an agreed framework. And so I think that sometimes I've asked some of the people who have been the most, the negotiators who've raised the most opposition, why did you agree to this in 2015? For whatever reason, they did agree to it, and we now have this framework. As with any international activity, a framework by itself is meaningless. You need to have accountability, and accountability means that states need to take action when the framework is not being observed. That's the only way you're going to get accountability. Only if states take action when the framework is not being observed. I'm a little harder on this than some people, but I'll quote a famous European statement who, when told that the Pope objected to some of his, and I'm a Catholic, so I can say this. The Pope objected to some of his activities. He said, "How many divisions had the Pope?" Now, of course, over the long term, the influence, the soft power of these organizations is important. But in the first instance, it is states and their ability to impose penalties or to be coercive in response to a failure to observe the norms that creates accountability. Only state action will create accountability. It can be reinforced by the private sector, and that's been very helpful when you think of the actions that have been taken in the past few years. They reinforce this framework. It's important to have the private sector, to have civil society involved in this and participating and lending their voice and their strength. But we need to think about what is the role of states in developing accountability. And part of this involves attribution. Sometimes you hear, and I hope the people who are attending this very valuable set of lectures leave with the understanding that attribution was indeed a major problem 10 years ago. It's decreasingly important as a problem. Several major cyber powers, and not all cyber powers are large states, but I would say there's probably half a dozen countries in the world that now can attribute the source of an attack in the majority of cases. Not all, but in the majority of cases. And of course, over time, and if the actions are repeated, attribution is less and less of a problem. And it wouldn't be a surprise if 5 years from now, attribution was not a problem at all. So sometimes you hear people say, we don't know where the attack came from. Nonsense. We know where the attack came from. The question is, what do we do about it? Because attribution in itself is not that useful unless it's accompanied by action. Sometimes you hear the phrase name and shame. Well, no big power on any side of this dispute, no big power is going to be shamed. They just aren't going to be embarrassed. Of course, we know what they'll do. The first thing they'll say is, "Oh, it wasn't us. How could you even think that?" We see this not only in cyber, but in many, many areas of coercion and the use of force or the threat to use force. So it's not so much the ability to determine who is the attacker. It's the ability to take action as a result of that determination. There is a dilemma here for cooperation among like-minded states, which is very often the ability to attribute is based on very sensitive intelligence activities. And I've had this discussion with a European country. They said, look, you, the United States, say that you know who the source of the attack was, and it's based on intelligence methods, but you won't tell us what they were, right? And so we have to go to our parliament and get approval for joining you in some response action. To do that, we can't just go in and say, the Americans told us and we believe them. We need something else. This is a dilemma for attribution. Not that attribution is hard, but that we can't always share what's been done in that regard. This is, again, where the framework for norms is helpful. If we can make the attribution, if everyone agrees on the attribution, we can then use that as the basis for action against the state that violated the agreed norms or that failed to observe the agreed norms. So an increasingly important problem, but it falls into this category of what are the actions we as an international community will take to enforce, to require observation of norms. And I'll stop there.
Thank you so much, James. And I hope that we can really work on all these avenues. And we really are very thankful for you to join us today and discuss and explain all these difficult concepts for all our viewers. As I understand, we have viewers from all over the world, from Africa, India, Latin America, and so questions for you were most numerous, I must say. So thank you for answering, and thank you also for being the first lecturer at our virtual masterclass.